Hello, good afternoon. Welcome to our third life sciences session, in which we will discuss what not to do in case of pricing of medicines. We've chosen the title Trop is te veel, which is a rather famous French-Dutch saying, meaning too much is too much. And we will discuss with you the pricing of medicines in Belgium. So the overview of today's presentation will consist of two main parts. I think actually we can say there's one appetizer, and that is what I will be presenting to you, which is pricing and reimbursement in Belgium from a procedural regulatory perspective. And there's also excessive pricing in the pharma sector under competition law scrutiny, discussed by my competition law colleagues, Beatrijs, Gielen, and Nina Methens. To introduce myself, I'm Kirian Claeyé, also active at Altius as a managing associate. So to start with pricing and reimbursement in Belgium, as I said, it's just an appetizer. So there can be said a lot about pricing and reimbursement in Belgium. There's a lot of information. You will see on the slides that I've also included a lot of information. And it will consist first just how to bring a medicine on the market, the legal framework in relation to the pricing and reimbursement of medicines, the reimbursement procedure, how does it work, what is relevant there, and also what with managed entry agreements. So to start with marketing of medicinal products, as most of you will know, the marketing of a medicinal product in Belgium, in any case, but in most European countries, requires, of course, a marketing authorization, that's everywhere in Europe, and the setting of a maximum price. In Belgium, the drug reimbursement of that product is furthermore optional, although, of course, when you have a product that can be reimbursed, it's actually a step that you will take, of course, because it means that the Belgian authorities will reimburse the product rather than the patient, which is from a commercial perspective, of course, much more valuable. The marketing authorization is done by the European Medicines Agency, granted by the European Medicines Agency or the Federal Agency for Medicinal and Health Products in Belgium. The setting of a maximum price is done by the Federal Public Service, in particular the pricing service, as well as the Minister of Economic Affairs. And the drug reimbursement is in the hands of the National Health and Disability Insurance Institute, and particularly the Commission for Reimbursement of Medicines, as well as the Minister of Social Affairs. There's also the advice in that regard from the Minister of Budget. So just let us look into what price and drug reimbursement actually, how does it work? The legal framework is the law of 14 July 1994, as well as the Royal Decree of the 1st of February 2018. Those two main legal bases lay out the groundwork for what you need in terms of the reimbursement of your medicinal product. The Royal Decree, can somebody mute? Yeah, the Royal Decree of the 10th of April 2014 is related to the fixing of price. So the pricing and reimbursement procedure, grosso modo, looks like it's been included on the following slide. And that's interesting because this slide is actually already rather old. It dates back to 2009. And the reimbursement procedure, from a large perspective, is still broadly or largely the same. As I said before, it's the Commission for Reimbursement and the Minister of Social Affairs that will be involved with the reimbursement procedure. Is the Minister of Economic Affairs that will be involved with the pricing procedure, and the two of them will run parallel to one another. The Commission of Reimbursement for medicinal products in Belgium consists of 23 voting members and a couple of non-voting members, among which some representatives from the pharmaceutical industry themselves as well. But looking back to what this procedure in itself looks like, the Commission of Reimbursement for Medicinal Products will first come up with a first assessment report that is under the regular pricing and reimbursement procedure. A first assessment report on day 60 a provisional appraisal report on day 120, and a final appraisal report with its opinion and the advice on day 150. And at that point in time, the question will arise whether or not managed entry agreement should be entered into. The Minister of Social Affairs will be the one taking the eventual decision, but he can only deviate from the final appraisal of the Reimbursement Commission if it is for budgetary or social reasons. Largely, I think this is more into detail, an overview of the Belgian drug reimbursement system, which, as you see, there's a lot of going back and forth to the applicant of the reimbursement, but from a broader perspective, it's the 60 days, 120 days, 150 days, and 180 days procedure, the one that I've discussed before. Now, what is relevant from a pricing and reimbursement perspective for you as a company or for an applicant applying for reimbursement of the product? It's on the one hand, the reimbursement criteria. And these reimbursement criteria, in particular the therapeutic value of your medicinal product, will decide on what reimbursement class you can ask for reimbursement, or you will be granted for reimbursement. Because a lot of companies will ask for class 1, and then the Reimbursement Commission will decide whether class 1 is actually justified or whether it should be class 2. I will discuss that in a bit more detail later on. The reimbursement modalities, that relates to setting the reimbursement basis, but also a reimbursement category, a reimbursement group, and the reimbursement conditions. The reimbursement conditions will also be tied together with the reimbursement chapter under which your medicinal product will be reimbursed. That's from a very broad perspective, but let us look into what this means in a bit more detail. The reimbursement criteria are the following. It's the therapeutic value, it's the price and proposed reimbursement basis, it's the importance in medical practice for the therapeutic and social needs, it is the impact on healthcare expenditures, and it's also the relation between healthcare costs and therapeutic value. Now, the therapeutic value, that is what as I said before, what will decide and what will grant you your reimbursement class. The therapeutic value is assessed on the basis of 5 further sub-criteria: efficacy, safety, effectiveness, applicability, and comfort. And you will always compare to what is already on the market to decide whether or not your medicinal product has an added therapeutic value, in which case you have the possibility of a price premium, or whether it's a class 2 product, a similar or analogous therapeutic value, and you have subclasses 2A, 2B, and 2C. It will lead me too far to discuss these into more detail, but don't hesitate to ask questions if you have. And class 3 is the generics and bibliographic applications. It's for well-established use. It's 3A, 3B, 3C. It's also biosimilars that will largely fall under this class. And that therapeutic value, as I said, whether or not you're in class 1, class 2, or class 3, will have an impact on a number of aspects. On the one hand, it will have an impact on the reimbursement procedure. Do you have to go through the normal reimbursement procedure, the one of 180 days that I've discussed before? Or can you use an administrative procedure for class 2A and 3A, as well as parallel import products, largely? Or can you use a 90 days procedure in case of class 2C, 3B, 3C, or biosimilar products? And this will also impact which reimbursement criteria will actually be looked at and which will be relevant in terms of your application. So, as I said before, it also has an impact on the price and reimbursement basis of your product. If you're in class 1, if you have an added therapeutic value that you've demonstrated, because you can apply for class 1, but it's not, as I said before, granted that you will obtain reimbursement in class 1. But if you're granted class 1, you can have a price premium compared to other medicinal products, because you've also showed that there is an added therapeutic value. Class 2, on the other hand, is a price that will be set in function of the prices abroad and that of comparator products. Class 3 is the fixed lower price than the reference product, for instance, for the generics, the biosimilars, and so forth. So that was it from the perspective of reimbursement criteria, but there's also the reimbursement modalities. It's going through this, and I think it's, like I said before, there's a lot of information, and I'm just trying to give you a flavor of what's there and how it's done on the Belgian level. The reimbursement modalities, one of them is, of course, the reimbursement basis, which will be your reimbursement basis of your medicinal product. There's also the reimbursement category that will actually establish the percentage of that reimbursement basis that is actually reimbursed, because this may sound weird, but it's not because your reimbursement is set at a certain value that 100% of that value or reimbursement basis will effectively be reimbursed. That is what your reimbursement category will decide or determine. There's also the reimbursement groups, more into detail, but that would lead me way too far for the purpose of the present presentation, and the reimbursement condition and reimbursement chapter. Let us first look into the reimbursement category. There are 7 categories, and like I said, it will determine the percentage of the reimbursement basis that is actually reimbursed. A and FA are for vital drugs. F means a forfeit, so it's also at the level of the hospitals. B and FB is therapeutically significant but non-vital drugs, and they are reimbursed largely for 75 to 85%. C is therapeutically less significant drugs at a reimbursement percentage generally of 50%. And then there's still CS and CX as reimbursement categories. But there's also, like I said before, the reimbursement conditions. And so we've had the classes generally, whether or not there's an added therapeutic value. There's been the reimbursement category, whether or not a drug is considered also vital, even if it's comparative therapeutic value, it can still be in the cure of cancer, so it's a vital drug. And then finally, there's the reimbursement conditions and reimbursement chapters, and that will actually determine which restrictions there are and to which extent they are actually verified by the competent authorities. In case of Chapter 1, there are no reimbursement restrictions. Of course, there is the indications that are listed in the SMPC, but there is no control on what and for what purposes your drug is reimbursed. In case of class reimbursement Chapter 2 or Chapter 4, there will be a control. In case of Chapter 2, there will be control after you've actually purchased and have been prescribed as a patient that particular drug. In case of Chapter 4, there is an a priori control. So before you've actually been prescribed your product or reimbursed, there will be a control by an advising physician at the sickness funds. Finally, the managed entry agreements, and that's the last point of my presentation, is it's part of the reimbursement procedure, but it's a story apart because it is at day 150, a final proposal may lead to negotiations for a managed entry agreement. Now, when is that actually relevant? If there's a disagreement on the clinical uncertainty of the drug that will be reimbursed, or if there is also budgetary uncertainty. It will be done at the initiative of the applicant or the reimbursement commission or the Minister of Social Affairs. And in view of that, you will have to go through different modalities during the negotiation for that managed entry agreement. Because what is the managed entry agreement? It will be an agreement that is concluded between the applicant on the one hand and the Belgian authorities, the Minister of Social Affairs and the National Health and Disability Insurance Institute, that will actually conclude an agreement which grants temporary reimbursement for the duration of 1 to 3 years, which is renewable for 3 years as well, and in which there will be modalities for compensation of the budgetary risk. That is often a refund, a percentage that is refunded. So your reimbursement basis is set at 100%, but there is a clawback or a pay refund to the Belgian authorities of, for instance, 30%, with tranches where the percentages can go up with a maximum cap, for instance. But there's also the possibility under managed entry agreements to introduce modalities such as pay for cure rather than pay for product. And I think from a general perspective, there's an overview on this slide where you can see there are financial-based arrangements that are possible, but there are also performance-based or risk-sharing arrangements to verify and utilize a product in real world. I think from a Belgian perspective, that gives you a flavor of the procedure that you have to go through and the negotiations that you can do, and in which circumstances you also have some leeway to negotiate on your price or to perhaps push the Belgian authorities on the price. And that is, I think, what brings us nicely into the second section, which will be presented by Beatrijs and Nina on the excessive pricing in the pharma sector under competition law scrutiny. Thank you very much and enjoy the rest of the session.
Hello, everybody. So Kirian explained us the rules on pricing of medicine in Belgium, pricing as it should be, pricing in the normal world. But what if it goes wrong? More importantly, what and when do authorities think that it goes wrong? When do authorities think that you are charging excessive prices? Now, before we turn to the rules set by the case law to determine when prices are excessive, let's first have a look at the specific background of the pharma sector, and in particular, the typical R&D and commercialization cycle in the pharma sector that has an influence on the pricing in the sector, and that explains the focus of competition authorities on excessive pricing in the pharma sector. Now, here we see the typical pharmaceutical product life cycle. As you can see, there are three typical stages. First, there's the early stage. That is the stage of the innovation, the stage of R&D. That's the stage where a pharmaceutical company makes costs. Second, the second stage, then the product comes on the market. Normally, you have a patent, and therefore you obtain market exclusivity for the product. That is, of course, the stage in which you can make most gain. However, after a couple of years, companies lose their patent, and market exclusivity is no longer there. So generic companies can enter the market. This is the stage where there will be normally a price competition, but in this stage, companies, of course, still try to recoup their initial costs and try to make some profits. Now, the risk of excessive pricing is particularly high in this late stage. Why? Well, the product has become off patent. There is less or even no regulation on the pricing of medicines because authorities want to stimulate price competition. But of course, that also opens the opens the door for higher prices, especially if there are no or almost no alternatives on the market. So that's why competition authorities mainly focus on this later stage. They are in particularly alerted if prices do not drop in that late stage, or if they even suddenly increase again. Now, the question is, should competition law intervene in that late stage for reasons of fairness? Now, there are split views on market intervention. Some people say that we have to trust in the self-correcting mechanisms of the market, while other people say that we cannot trust in that because if it doesn't succeed, there is a huge welfare loss. There will be illnesses and related costs for society. However, the current view in Europe, therefore, is that competition authorities should intervene in case of excessive prices. So on what legal basis do they intervene? Well, that is typically done on the basis of Article 102 of the Treaty on the Functioning of the European Union and the equivalent provisions in national EU member states. That Article 102 says that any abuse by one or more undertakings of a dominant position within the internal market or in a substantial part of it shall be prohibited as incompatible with the internal market insofar as it may affect trade between member states. This means that there are two requirements to find an infringement of Article 102, namely dominance, and second, an abuse with effect on competition. Now, if you infringe Article 102, so if you abuse your dominant position, there are severe sanctions that can be imposed. You risk a fine of up to 10% of the worldwide turnover, injunctions in the form of a cease and desist order, commitments, private damages, all these types of sanctions can be imposed. So the initial requirement to find an abuse of dominance is dominance. The competition authority first will have to indicate what the relevant market is, and only when it has determined the relevant market, it can check whether the company is dominant on that relevant market, and that assessment will generally be done on the basis of market shares. And then once a company is established to be dominant, the competition authority will have to show that there is an actual abuse. Now, Article 102 lists examples of behavior that can be considered as abusive, and one of these examples is to directly or indirectly imposing unfair purchase or selling prices or other unfair trading conditions. Now, this is understood to cover charging excessive prices. Now, when are prices excessive and abusive? Now, there have been very few cases on excessive pricing in the past in Europe. The landmark case is still the United Brands case of 1978 of the European Court of Justice. It's not in the pharma sector, but it's still relevant. This case says that prices are excessive when there is no reasonable relation to the economic value of the product. Now, the European Court of Justice has further developed in the United Brands case a two-step test to assess when prices will be excessive. First, there is the cost plus test, price-cost margin comparison. So that's the question whether the difference between the costs incurred and the prices charged is excessive. And second, it's a cumulative test. You have to check whether the prices are unfair. This can be either done by showing that the price is unfair in itself, or that the price is unfair compared to the price of competing products. Now, the application of this United Brands test in the pharma sector raises some particular questions and problems. First, let's have a quick look at the basic requirements of finding of an infringement of Article 102, namely the relevant market and dominance. So regarding the definition of a relevant market, a whole of problems can arise in the pharma sector. I will not go into detail. I think we can fill a whole separate webinar on this, but questions arise like which level of the ATC classification should be taken into consideration to determine the relevant market, or whether, for example, off-label and on-label use of a medicine would constitute the same market. Regarding dominance, competition authorities should keep in mind that the fact that the pharmaceutical company has an intellectual property right does not mean that that company also have dominance. It can be, but it's not automatically so. And of course, competition authorities also have to watch out for a circular reasoning. They cannot say that a pharmaceutical company is dominant, has market power, because apparently it is able to charge a high price, and then at the same time say that those high prices are excessive because the company is dominant. That would be a circular reasoning which cannot be accepted. Second, some problems or questions arise in the application of the first step of the United Brands test. This first step was the cost-price comparison. Of course, this requires a solid information to assess the relevant costs. But how to measure the costs in the pharma sector? As you know, of course, pharma sector is based on a lot of R&D, but do you take into consideration all R&D over what time period? And what to do with multi-product firms with a common cost? How to allocate costs to different medicines? Luckily, the European Court of Justice has already shed some light in this regard and has explained that, for example, abortive research and development should be taken into consideration. Problems regarding the first leg of the second step, the test whether the price is unfair in itself. The European Court of Justice has explained that this test is meant to cover those instances in which the unfairness of a price can be determined without the need to make any comparison with similar or competing products. That's a very nice statement, but the question remains, when is a price in itself unfair? To answer that question, we should also take into consideration the specific nature of the pharmaceutical products, and in particular, the price inelasticity of medicines. When we're talking about normal product, we are in this graph on the left hand. So typically, the demand decreases when prices increase. However, in case of medicines, and in particular for life-saving drugs, you will see that patients will want to have the medicine irrespective of the price. So we have a perfectly inelastic demand. So then the question is, at what level in this graph would we say that the price is inherently unfair? And then the question is, do products in fact have an inherent unchanging value? For example, let's take gold versus water. Probably a lot of people will say that gold has a very high inherent value and that it's worth much more than water. Probably that is true for this person, but probably not for this person. Then there are also some problems with the second leg of the second step, the unfairness compared to the price of competing products. This means that we will have to compare the price of the medicine with prices, for example, in other countries. But the question is whether that comparison is relevant if there is a different regulatory framework in different countries. We should compare the price with the historical prices, but prices can change very rapidly. We can make a comparison with prices of competitors' products, but the problem is often that such competitor products might not be available. That is often exactly the reason why a pharmaceutical company is able to charge such a high price, because there are no alternatives. And if we make those comparisons, then the question is still, when is the difference unfair? Now, the courts have already said that there is no minimum threshold for unfairness. The Court of Justice has also explained that this is in fact a sanity check. So the price, when you compare it to other products, will be considered as unfair if there is a significant and persistent difference from this benchmark price. That's an indication of abuse. However, there's always a but. However, there can always be a rational economic explanation, and that will explain that the high price is not abusive. Now, there have been many cases in the recent past at the national level applying this United Brand Test. A very famous one is the UK Pfizer versus Pfizer and Flynn case. What happened in this case? Well, this case concerned an off-patent medicine. Pfizer had transferred its marketing authorization for this medicine to Flynn, but continued to manufacture and supply this product to Flynn for the distribution in the UK. And at that moment, Pfizer significantly increased its price to Flynn, and Flynn, on its turn, significantly increased the price to its customers. Now, the UK Competition and Markets Authority found that these prices were unfair in itself. So the Competition Authority applied the first prong of the second step of the United Brands case, and for that reason decided that the prices were excessive and imposed high fines both on Pfizer and Flynn. This judgment, this decision, however, was appealed, and the UK Competition Appeal Tribunal and the Court of Appeal both said that that the decision of the UK Competition Authority was wrong. In particular, there were many issues, but the main issue was that they said, look, a competition authority has some freedom to make its own case and to determine the methodology they are using to assess whether the prices are excessive, to assess whether there is an infringement. However, in this case, the parties had brought evidence that the prices were not unfair when compared to competing products. And the Court of Appeal said that the authority cannot disregard such evidence. Another national case is the Danish CD Pharma case. In this case, CD Pharma also increased its prices at a certain moment to a very high extent, with 2,000%. The Danish Competition Authority applied the United Brands. That's the different steps. So first they had a look at the cost, and then they compared it to, for example, prices in other countries. Also, they made a comparison with historical prices, and on that basis, they concluded that the prices were excessive, and they ordered to terminate the infringement. Now, as we are in Belgium, it's also interesting maybe to see whether there are some Belgian cases on this issue. First of all, there is the Novartis-Roche case. Novartis product Lucentis is officially registered for eye disease, but it's very expensive. Roche Avastin product is officially registered for cancer, but it is already used for a couple of years off-label for the same eye disease, and it is much cheaper. Now, Novartis and Roche were alleged to try to discourage the use of the cheaper Avastin for eye disease and to charge excessive prices for Lucentis. Now, this case has already been the subject of other decisions of national competition authorities. There has also been a European judgment on the off-label versus on-label use of medicines and whether they belong to the same market. But the Belgian Competition Authority is still looking into this case. They are saying that it's quite a complex case. They hope, however, to get back on this case in the course of this year. Another Belgian case that is pending is the Leadient case. The Leadient medicine contains the molecule CDCH, which is used to treat gallstones, but it is also used already for a couple of years off-label to treat a rare genetic metabolic disease. Now, Leadient increased its prices for the drug, and Test Achat, the Belgian Consumer Association, filed a complaint with the competition authority claiming that those prices are excessive. The Belgian Competition Authority is still looking into the case. They hope to finalize the investigation this year. Finally, in Belgium, there's also the Biogen case, which is pending. Biogen's medicine Spinraza is used to treat spinal muscular atrophy. Again, the Belgian consumer organization Testachat claims that the price does not correlate to the investments made because the research would have been done in a university environment and therefore largely financed with public funds. This case is still pending before the Belgian Competition Authority. We have no further information on that. Now, because we are talking about pending cases in Belgium, I do want to draw your attention to a new provision which is in force in Belgium since August 2020, a prohibition on the abuse of economic dependence. Now, interestingly, this prohibition prohibits behavior that is similar to behavior that is prohibited under Article 102, so under the prohibition of abuse of dominance. However, to find an infringement on the provision of abuse of economic dependence, there's no need to find a dominance. It's just when there is economic dependence, so when one company is in a position of submissiveness towards another undertaking. The Belgian Competition Authority has indicated that it has already received some serious complaints under this new act. We don't know whether that would also include complaints in the pharma sector, but nevertheless, it's an interesting provision to keep in mind. There are other examples of pending cases in other countries, other cases in the UK, in the Netherlands, in Germany as well. I'm not going to go into detail on all these cases because I think it is now time to give the floor to my colleague Nina, who will guide you to one more very interesting case, the Aspen case. Well, Nina, she will explain you why this case is so interesting. Thank you very much.
Hello, everyone. So, as Beatrijs said, another case that has started at national level but was later on picked up by the Commission is the Aspen case. The case first started in Italy, and it concerned certain cancer medicines, which are used in particular to treat certain forms of leukemia. So Aspen, the company under the radar in this case, purchased the marketing rights from the originator GSK in 2009. And at that time, these medicines were already off patent for approximately 50 years, meaning that, as Beatrijs explained, the R&D costs had been largely recouped by then. Aspen, in the following years after acquiring these marketing rights, increased the prices of these medicines with 300 to 1,500%. And it applied very aggressive tactics towards the Italian Medicines Agency when negotiating these prices, including threats to initiate so-called termination supply, which basically means that it was threatening to withdraw supplies of the drugs if the Medicines Agency did not accept to comply with the requested higher prices. So following its investigation, the Italian Competition Authority found an abuse of Aspen's dominant position in 2016 by way of imposing excessive prices, and it imposed a fine of 5.2 million euros on Aspen. The Italian Competition Authority applied the two-steps test of United Brands. And when applying the first limb, it showed that prices of Aspen pre-increase were already profitable when compared with Aspen's cost, which means that the increase of prices amounted to the excess of prices. So it found that the prices were excessive. And second, it also found when applying limb 2 of the United Brands test, that there were actually no alternatives, neither in Italy nor abroad, with which that the prices for these products could be compared. So it compared the different level of the product's current prices to the prices applicable before the increase. And the competition authority concluded that the sole aim of Aspen was to obtain a high price increase, and that it didn't do so with any necessary economic justification. Following this decision, Aspen had to reach a new agreement with the Italian Medicines Agency on the prices for these particular medicines. And when it did so, the Italian Competition Authority determined that Aspen was not compliant with its decision. The Competition Authority's decision has been upheld before the Administrative Regional Court, but an appeal is still pending with the Italian State Council, so we'll still have to see what will be decided on that level. Following this case in Italy, the European Commission, on its turn, initiated a formal investigation regarding Aspen's abuse of dominance, but this time in the EEA, except for Italy, since a decision had already been taken by that competition authority. Should be noted that it's actually the first time that the European Commission, so at EU level, is taking a decision on excessive pricing in the pharmaceutical sector. As explained by my colleagues before me, so far such decisions had only been taken at national levels by either competition authorities or consumer protective bodies. The case investigated by the Commission concerned the same cancer medicines as the ones investigated by the Italian Competition Authority, plus a sixth medicine called Mileron. The competition concerns were also largely the same. So the Commission found again that Aspen was using threats to withdraw those medicines from the national list of medicines that would be reimbursable. And in some cases, Aspen was even ready to withdraw the medicine from normal supply in the markets. Again, it's important to stress that Aspen could achieve these high prices because patients and doctors did not have any alternatives to using these particular medicines. And those cancer medicines were completely essential and still are life-saving for the patients actually needing them. In July 2020, Aspen proposed commitments to address the European Commission's concerns. So the Commission opened a consultation in order for stakeholders to be able to give their inputs as to whether the proposed commitments by Aspen would indeed effectively be able to remove the competition concerns in the markets. And following that consultation, Aspen made adjustments to the commitments that it had already proposed. And roughly a month ago, on 10 February 2021, the European Commission considered that Aspen's commitments were satisfactory and accepted them. So it took a so-called commitment decision, which made those offered commitments legally binding on Aspen. Now, before going into more detail into what those commitments actually were, maybe a few words on what a commitment decision is. When the Commission has identified practices in the markets which may be problematic under competition law, it can start an investigation into these practices. And in that case, the company under investigation may voluntarily offer commitments which are intended to address the competition concerns that the Commission has identified so far. And if the Commission finds that there is good reason to believe that these commitments will effectively address the competition concerns, it will then draft a preliminary assessment, which is a summary of the main facts of the case and of the competition concerns that the Commission has in that regard. And based on that preliminary assessment, the undertaking under investigation may then put forward commitments that it will deem appropriate to address the Commission's concerns. And if the Commissions accept the commitments, it will adopt a decision making those commitments binding on the parties. Now, the main difference between a commitment decision and a prohibition decision, such as, for example, the one that was taken by the Italian Competition Authority in the Italian Aspen case, is that in a prohibition decision, the Commission will find that there is an infringement against the undertaking, while it doesn't do so in a commitment decision. So a commitment decision will only refer to concerns that were expressed by the Commission, but will not, in every case, assess what behavior could constitute, in that case, an infringement. Of course, a commitment decision has many advantages, especially for the undertakings that are or were under investigation, because no infringement is established against that undertaking, and as a result, no fine is imposed. But however, it's important to keep in mind that when the Commission accepts legally binding commitments, it will monitor those commitments, and if the undertaking that committed to respect those engagements doesn't do so and doesn't comply with what it has promised, the Commission is allowed to either reopen the investigation, pick it up where it left it off, and conclude to a prohibition decision in the end, or it can even impose a fine without having to demonstrate that an infringement has been committed. Another clear advantage of commitment decisions is that they're usually faster than the whole proceedings that lead to the adoption of prohibition decisions, and that allows to introduce lasting and fast changes in a market that could be highly disrupted. And last but not least, commitment decisions also allow to take into account the interests of third parties. In the Aspen case, for example, it's not only important to ensure that prices of these essential medicines remain fair and are not excessive, but it's also very important to ensure that those medicines, those drugs, continue to be supplied, since there are no alternatives in the market to those medicines. Two disadvantages, one could say, of commitment decisions is that, unfortunately, as I already said, the Commission, as opposed to prohibition decisions, does not make a clear analysis, clear identification of what behavior it considers to constitute an infringement. And moreover, commitments are very case-specific, because they're really a dialogue between the undertaking under investigation and the Commission. And so there's never any certainty that if in some cases commitments were offered and accepted by the Commission would actually adopt the same reasoning in subsequent cases. Now back to the Aspen case. When the Commission decided to hear what Aspen had to offer as commitments, it issued its preliminary assessments, and its investigation showed that indeed Aspen's prices exceeded its relevant costs by almost 300% on average, and that was 300% including when taking into account a reasonable rate of return. The Commission also said that there were no legitimate reasons for Aspen's very high profit levels, especially since the medicines had been off patent for 50 years. And the Commission stressed again that Aspen could achieve these price increases because patients and doctors mostly had no alternatives to using these particular cancer medicines, and there were no alternative suppliers. Now, which commitments did Aspen offer? In particular, there were three sets. The first one was the price reduction. So Aspen committed to reduce its prices across Europe for the 6 cancer medicines by, on average, approximately 73%, which meant that the prices will drop below the prices of 2012, which is when Aspen started to increase its prices. And after the price reduction, it's important to note that the net prices for the different medicines will still vary between the member states. So not all medicines will have the same prices in all member states. And this is because the reduced net prices have been determined based on Aspen's costs. And Aspen's costs obviously differ considerably across products and across member states. The second commitments are the fixing of a price ceiling. So the reduced net prices will be the maximum prices that Aspen can charge for the 10 coming years. But that means that the prices are not fixed and that Aspen is always free to negotiate and charge with member states on lower prices. And during the second half of that 10-year period, so after 5 years, Aspen will be allowed to review its net price ceilings one only time if it is able to prove that its costs linked to these specific medicines have significantly increased by more than 20%. And third, Aspen guarantees the supplies of these medicines for the next 5 years. And for the additional period of 5 more years, it committed to either continue to supply these medicines himself or make its marketing authorization available to other suppliers. The commitments will remain in force for 10 years. They will be under supervision of a trustee attached to the Commission, and this trustee will be in charge of monitoring the implementation and the compliance with the commitments. Now, recently, the increasing interest of national competition authority and consumer protection bodies for excessive pricing have also, be felt in the times of COVID-19. Since the start of the pandemic, there's been a surge in demand for essential items such as face masks, hand sanitizer, also food items or funeral services. And sometimes these services or items have resulted in dramatic price increases. Now, in June 2020, an inquiry was sent to all competition authorities in Europe, seeking to gather data on three things. First, the number of excessive pricing complaints that were already received by authorities since the start of the pandemic. Second, whether investigations were open or pending in the respective countries. And third, what general position the competition authorities were assuming in regard to excessive pricing in general. 23 competition authorities provided answers to the inquiry, but the results were highly divergent. In some member states, the competition authorities reported hundreds of complaints. In other ones, only few ones or even none. Some member states engaged in investigations. Others introduced active maximum pricing laws for essential items, for example. So we can basically distinguish two categories of measures that the member states have adopted as a result of the pandemic. Some countries actively decided to intervene in the price setting and have fixed maximum prices, while others have opted to more generally closely monitor prices and price increases, and in some cases where necessary have opened investigations into some of these practices. Sorry. Some of those countries, as France, Malta, and Croatia, have adopted price regulations, and they have set maximum prices for some items. For example, in France, the prices of alcoholic sanitizers have been regulated. So for 50 millimeters bottles, the price was capped at €2. For 100 millimeter bottles, the price was capped at €3, and so on. And France has also fixed prices of surgical masks at 95 cents. And in Malta and Croatia, also similar price control measures have been adopted for certain products considered essential, such as protective face masks. But in a lot of other countries, competition authorities or consumer protection bodies have launched formal investigations into some pricing practices that were adopted or have emerged since the start of the COVID pandemic. In the UK, for example, the Competitions and Markets Authority has launched 4 investigations already into suspected charging of excessive and unfair prices. But the CMA has observed that after a few months, those prices went down again. So it considered that there was no reason to conclude for excessive prices under competition law, and it closed its investigations. In Greece, the Hellenic Competition Commission also launched an inquiry into possible price increases of healthcare materials, such as surgical masks, disposable gloves, and antiseptic solutions. And it did so based on an algorithmic approach that basically analyzed the prices and gave an overview of prices that had been subject to a large increase in the last month since the beginning of the pandemic. And based on that algorithmic approach, the Competition Commission sent requests for information to a large number of companies that were active and still are active in the production, import, and marketing of these healthcare products. And in Belgium too, the Competition Authority has indicated that it was pursuing a case under competition law rules, but for confidentiality reasons, it has not disclosed more details yet about these ongoing investigations. Now, other countries such as Italy, Sweden, Spain, and Poland, for example, have also been closely monitoring prices of those essential items. in light of the complaints that they have received, but no formal decisions have yet been taken. So from a general perspective, we could say that the rapid reaction of many European member states in the face of price increases since the start of the COVID pandemic show that there is a strong will to ensure that products that are considered essential to protect the health of consumers remain available at competitive prices. And through their different initiatives to reach that goal, the member state have again showed that they would not hesitate to take action about companies that would take advantage of the current situation to abuse their dominant position. And even, for example, the CMA, to take this last example, the CMA has stressed that the decision to close its investigation did not amount to a definitive statement as to whether the party to the investigation has infringed competition law. And the CMA's decision to close this case does not prevent the CMA from opening an investigation in the future if it were to receive new evidence which changed the assessments. By way of conclusion, case law has identified some criteria that, in combination with one another, can point to a rather higher or lower risk of existence of an abuse of dominance by way of excessive prices. So when a market is characterized by high and non-transitory barriers to entry, such as is the case in Aspen, and that the case concerns essential, crucial medicines for which there are no alternatives, the chances are always higher that competition law concerns could arise in comparison with markets that allow recent and continuous entry, where alternative medicines are available and that the medicines are less crucial, less life-saving, so to say. And the last point that I think is also important to point out in this case is that the fact that off-patent drugs that have price increases applied to them are more dangerous and bear a higher risk, as well as being found problematic under competition law than innovative new drugs, because of this whole thing of R&D costs having been recouped for a longer time. Finally, we can say, and we see in the existing case law, that national enforcement is more likely than enforcement at European level. That is because of the particularities of the pharmaceutical sector and the fact that price negotiations and price setting is done at national levels with national authorities and agencies and not at a supranational level. And the Commission, as a competition authority, has also always been reluctant to intervene in such cases as a price regulator. The final question can be asked in those cases whether which remedy is best. Is it best to impose fines, to accept commitments? That will always depend on the specificities of the case. Fines can be deterrents, but commitments, as we have seen in the Aspen case, for example, allow to achieve rapidly solutions and change the market in a favorable way, and especially take into account the need of third parties that would not be remedied just by imposing a fine. Thank you for your attention. If you have any question, we're here.
Thank you, Nina and Beatrijs, also from my perspective. I wanted to add, just for your reference, so while we wait for questions, of course, if there are questions, shoot. And in the meanwhile, you can always stay tuned on our Altius Life and Health blog, which regularly updates, not only with questions from a competition law perspective, but also with questions from an IP or regulatory or public procurement perspective. There will be, we're intending to also provide a topic with key takeaways from today. And secondly, I would also invite you with pleasure, of course, to our next Life Sciences session, which will take place on the 25th of May, 2021, so in 2 months. And that will be on IP regulatory rights, supplementary protection certificates in particular, orphan exclusivity, regulatory data protection, and pediatric rewards. Then there's nothing left for us to thank you very much for attending, and that we look forward, of course, seeing you next time as well. Bye-bye.